This is a summary of Part 1 of the Computer Misuse and Cybercrimes Act of Kenya. Part 1 of this Act is titled Preliminary and defines the Act's purpose and key terms. Short title: The Act is called the Computer Misuse and Cybercrimes Act, 2018. Interpretation: The Act defines various terms related to computer systems and data, including access, which includes altering, copying, or using data or programs in a computer system. Computer system, defined as a device or set of devices that use technology to perform functions on data. Critical infrastructure, referring to processes and assets crucial for the well-being of Kenyans and the government. Data, defined as representations of facts or information that can be processed by a computer system. Interference, meaning any action that harms the confidentiality, integrity, or availability of a computer system. Network, defined as interconnected devices that share resources and information. Password, referring to data that allows access to a computer service or system. Program, defined as instructions that make a computer system perform a function. Service provider, referring to entities that provide communication means through computer systems or process data for others. Telecommunication system, defined as a system using energy to convey various forms of communication, including speech, images, data, and signals. Traffic data, meaning data about communication through a computer system, such as origin, destination, and time. Objects of the Act: The Act aims to protect computer systems and data, stop illegal computer system use, enable the handling of cybercrimes, safeguard privacy, free speech, and access to information, facilitate international cooperation on these matters. This section of the Act lays the groundwork for the subsequent sections, which address specific offenses and investigation procedures related to computer misuse and cybercrimes in Kenya. This is a summary of Part 2 of the Computer Misuse and Cybercrimes Act of Kenya. Part 2 of this Act focuses on the establishment, composition, and functions of the National Computer and Cybercrimes Coordination Committee, which plays a crucial role in addressing computer and cybercrime issues in Kenya. Establishment and composition: The Act establishes the National Computer and Cybercrimes Coordination Committee, referred to as the Committee in the Act. This committee comprises key stakeholders from various government agencies, including representatives from the security, information and communication technology, defense, intelligence, police, communications, judicial, and financial sectors. The committee reports to the Cabinet Secretary responsible for internal security. Functions: The committee is responsible for advising the government on security relating to areas like blockchain technology, critical infrastructure, and mobile money. Coordinating with national security bodies on computer and cybercrime matters. Developing a framework to safeguard Kenya's critical national information infrastructure. Coordinating responses to cyber threats and incidents both domestically and internationally. Establishing cybersecurity standards and best practices for entities managing critical national information infrastructure. Developing a national public key infrastructure framework. Creating training programs on preventing and mitigating computer and cybercrimes. Secretariat: The Act establishes a secretariat to support the committee's operations. This secretariat, led by a director appointed for a single 4-year term, handles the administrative tasks, implements the committee's decisions, and manages its budget. Critical information infrastructure. The director has the authority to designate systems as critical infrastructure if their disruption could severely impact essential services, the economy, national security, or lead to mass casualties. The director must inform system owners of this designation and provide reasons. The committee, in consultation with system owners, recommends entities to be officially recognized as critical information infrastructures after assessing their vulnerabilities to cyber attacks. Owners of systems designated as critical infrastructure must report cyber threats and incidents to the committee, which, along with the National Security Council, will provide technical assistance to mitigate these threats. Information sharing agreements between public and private entities are permitted to enhance cybersecurity, investigate cybercrimes, and protect national security. Strict measures are in place to protect personal information during such sharing. The Act mandates annual compliance audits of critical information infrastructures, outlines procedures for conducting these audits, and establishes penalties for non-compliance. Part 2 lays out the organizational and legal framework for Kenya to address cyber threats and protect its critical infrastructure. This is a summary of Part 3 of the Computer Misuse and Cybercrimes Act of Kenya. Part 3 of the Computer Misuse and Cybercrimes Act focuses on defining various cybercrimes and their corresponding penalties. The Act outlines offenses related to unauthorized access and interference with computer systems, illegal devices, cyber espionage, online content-related crimes, and financial cybercrimes. Here is a breakdown of the key offenses detailed in Part 3. Unauthorized access and interference. The Act criminalizes unauthorized access to computer systems, including instances where security measures are bypassed to gain access. It also prohibits actions that interfere with the functionality of computer systems, programs, or data. Illegal devices and passwords are manufacturing, distributing, or possessing devices, software, passwords, or access codes intended for committing cybercrimes is strictly prohibited. Cyber espionage. The Act addresses cyber espionage as a serious offense, carrying significant penalties. It prohibits unauthorized access to or interception of data from critical databases or national critical information infrastructure to benefit a foreign state. False publications. Publishing false or misleading information online with the intent to deceive or cause harm, especially if it incites violence, promotes hatred, or damages someone's reputation, is considered a criminal offense. Child pornography. The Act defines and prohibits all aspects of child pornography, including production, possession, distribution, and publication through computer systems. Cyber forgery. The Act criminalizes the act of manipulating computer data to create inauthentic information that is then presented as genuine for legal purposes. Financial cybercrimes. The Act addresses various financial cybercrimes, including using computers to commit fraud, stealing identities, phishing for personal information, intercepting electronic funds, and manipulating electronic payment systems for personal gain. Additional important points. Cyber harassment. The Act specifically addresses cyber harassment, defining it as using electronic communication to cause distress, fear, or harm to an individual. It allows for court orders to stop such harassment and mandates service providers to assist in identifying perpetrators. Cyber terrorism. Using computer systems or networks to plan or carry out terrorist acts is a serious crime under this Act. Reporting cyber threats. The Act mandates that entities operating computer systems or networks must report any cyber attacks or security breaches to the National Computer and Cybercrimes Coordination Committee. Employee responsibilities. Employees are required to surrender all access codes and rights to their employer's computer systems upon termination of employment. Penalties. Penalties for offenses outlined in Part 3 vary depending on the severity of the crime. They range from fines to imprisonment, with more severe penalties for crimes that result in significant financial loss, threaten national security, or endanger public safety. Various sections throughout Part 3. Part 3 of the Computer Misuse and Cybercrimes Act plays a crucial role in deterring and punishing cybercrime in Kenya. It provides law enforcement agencies with a legal framework to investigate and prosecute a wide range of cyber offenses. This is a summary of Part 4 of the Computer Misuse and Cybercrimes Act of Kenya. Part 4 of the Computer Misuse and Cybercrimes Act outlines the procedures for investigating cybercrimes in Kenya. This section focuses on providing a legal framework for law enforcement and authorized personnel to obtain digital evidence and investigate cybercrime effectively while respecting legal rights. Here's a breakdown of the key aspects of Part 4. Scope and applicability. The procedures outlined in Part 4 apply to investigating and prosecuting offenses defined in this Act. Investigating other criminal offenses where a computer system is used. Gathering electronic evidence for any criminal offense. Importantly, the Act clarifies that evidence originating from or transmitted through a computer system is admissible in court proceedings, regardless of its digital nature. Search and seizure. Part 4 grants law enforcement or authorized personnel the power to apply for a warrant to access, search, and seize electronic data from computer systems and storage devices. To obtain a warrant, they must demonstrate reasonable grounds to believe that the data is relevant to a criminal investigation or was obtained illegally. The Act details the requirements for a valid search warrant, including identifying the investigating officer and specifying the data or individuals subject to the search. It mandates that a copy of the warrant be presented to the individual or entity affected by the search. The Act also outlines offenses and penalties for obstructing the search and seizure process or misusing the powers granted by the warrant. Handling of seized data. The Act includes provisions to ensure the responsible handling of seized data. A detailed inventory of all seized items must be created during the search, and a copy must be provided to the owner of the premises or custodian of the data. Individuals with a legitimate right to the seized data, such as the owner or authorized personnel, are granted access to copy or inspect the data upon request. However, access can be denied if there are reasonable grounds to believe it would hinder the investigation, compromise ongoing legal proceedings, or constitute a criminal offense. The Act also provides a mechanism for affected parties to appeal to the court for access to seized data if they believe their rights are being infringed. Production orders. In addition to search warrants, the Act enables investigators to obtain a production order to compel individuals or service providers to submit specific data relevant to an investigation. This order can be used to obtain data stored on a computer system or storage device in someone's possession. Subscriber information held by a service provider. Expedited preservation of data. Recognizing that electronic data is volatile and can be easily deleted or modified, Part 4 allows for the expedited preservation of data, particularly traffic data. If there are concerns that data might be compromised, investigators can issue a notice for its preservation for up to 30 days, which can be extended with court approval. The Act makes it clear that the entity in control of the computer system is responsible for preserving the data's integrity and confidentiality during this period. Real-time collection of data. Part 4 provides mechanisms for the real-time collection of both traffic data and content data, recognizing the importance of this information in ongoing investigations. Traffic data. Investigators can obtain a court order to collect traffic data in real time if they can demonstrate that it is required for a specific criminal investigation. The Act outlines specific criteria that must be met to obtain such an order, including demonstrating the data's relevance to the investigation, identifying the specific types of traffic data required, specifying the individuals or accounts under investigation, detailing the alleged offenses, outlining measures to protect the privacy of uninvolved parties. Content data. The Act also allows for the interception of content data, the actual content of communications, in real time under strict conditions. The application process for this type of order is similar to that for traffic data, requiring investigators to provide detailed justifications and safeguards to protect privacy. Time limits and extensions. Orders for real-time data collection are subject to time limits, 6 months for traffic data and 9 months for content data. These limits can be extended with court approval if there is sufficient justification. Service provider obligations and penalties. The Act places specific obligations on service providers to cooperate with these orders and outlines penalties for non-compliance. Interception of content data. Recognizing the sensitivity of intercepting content data, the Act imposes stricter conditions compared to traffic data. The requesting party must provide compelling reasons, demonstrate that less intrusive methods are insufficient, and outline measures to minimize privacy infringement. The order's duration is limited to a maximum of 9 months, extendable under strict conditions. Obstruction, misuse of power, and appeals. Obstructing investigations, misusing investigative powers, and procedures for appeal are covered. The Act criminalizes actions that obstruct the lawful exercise of investigative powers, such as destroying evidence, and imposes penalties for such actions. It also recognizes the potential for abuse and holds law enforcement or authorized personnel accountable for any misuse of their powers under this Act. Importantly, any person aggrieved by a court order or decision made under Part 4 has the right to appeal to a higher court. Protection of service providers. The Act recognizes the role of service providers and provides them with certain legal protections. Service providers are not held liable for simply providing their services or for disclosing information as required by law or court order. However, they are obligated to cooperate with law enforcement and adhere to the provisions outlined in Part 4. Various sections within Part 4. Part 4 of the Computer Misuse and Cybercrimes Act is crucial for equipping Kenyan authorities with tools to combat cybercrime effectively. However, the Act emphasizes a balanced approach, ensuring that investigative powers are subject to judicial oversight and safeguards to protect individual rights and privacy. This is a summary of Part 5 of the Computer Misuse and Cybercrimes Act of Kenya. Part 5 of the Computer Misuse and Cybercrimes Act of Kenya establishes a framework for international cooperation in combating cybercrime. Here's a breakdown of Part V's key provisions. Relationship with existing laws. Part 5 operates in conjunction with Kenya's existing laws on mutual legal assistance and extradition. These include Mutual Legal Assistance Act, 2011, No. 36 of 2011. Extradition, Contiguous and Foreign Countries Act, Cap 76. Central Authority for International Cooperation. The Act designates the Central Authority, the Office of the Attorney General and Department of Justice in Kenya, as the primary point of contact for all incoming and outgoing requests related to international cooperation in cybercrime matters. Types of assistance covered. Part 5 outlines various forms of mutual legal assistance that Kenya can provide to or request from other countries in cybercrime cases. This assistance includes investigating cybercrime. This includes traditional investigative actions adapted for the digital environment. Collecting electronic evidence. This recognizes that evidence in cybercrime cases often crosses borders and exists in digital formats. Obtaining and preserving data. This encompasses the various powers outlined in Part 4 for securing data from service providers, including expedited preservation and disclosure of traffic data, real-time collection of traffic data, interception of content data, making and responding to requests. Outgoing requests. The Central Authority in Kenya is authorized to request assistance from other countries, referred to as requested states, for the purposes mentioned above. Incoming requests. Other countries can also request assistance from Kenya, referred to as the requesting state, through the Central Authority. Granting or refusing assistance. The central authority in Kenya has the discretion to grant or refuse incoming requests for mutual legal assistance, considering the provisions of relevant Kenyan laws and international agreements. Confidentiality. The central authority can impose confidentiality requirements on the information shared with other countries to protect the integrity of investigations and sensitive data. Specific mechanisms for cooperation. Spontaneous information sharing. The central authority can share information with another country even without a formal request if it believes that the information would be helpful in investigating or prosecuting a cybercrime. This provision recognizes the importance of timely information exchange in cybercrime investigations. This sharing is subject to confidentiality requirements and conditions to ensure that the information is used appropriately. If the receiving country cannot comply with these conditions, they must notify Kenya, which can then decide whether or not to proceed with sharing the information. Expedited preservation of data. Recognizing that digital evidence is volatile, the Act allows a requesting state to request the preservation of specific data located in Kenya even before submitting a formal request for mutual legal assistance. This provision buys time for the requesting state to prepare and submit a formal request while ensuring that critical data is not lost. The requesting state must provide specific information, including details of the offense, the data to be preserved, and the reasons for preservation. The initial preservation period is 120 days, which allows the requesting state to formalize its request for assistance. Expedited disclosure of traffic data. When executing a mutual legal assistance request, if it is discovered that a service provider in another country is involved in the communication being investigated, Kenya will promptly disclose necessary traffic data to the requesting state. This speeds up the process of identifying relevant parties in cross-border investigations. Accessing stored computer data. The Act sets out a detailed procedure for requesting access to, seizure of, or disclosure of data stored on computer systems located in Kenya. The requesting state must provide comprehensive information about the offense, the data sought, its relevance, and any available information about the data's custodian or location. Kenya, through the central authority, will then take steps to obtain the necessary legal authorization, such as a warrant, to execute the request. Cooperation and support during the search and seizure process can be provided to the requesting state. Transborder access to public or consensually shared data. Recognizing that some data may be publicly accessible or shared with consent, the Act allows for its access even if it is stored outside Kenya, as long as the data is publicly available. Lawful and voluntary consent is obtained from the person authorized to disclose the data. Real-time collection of traffic and content data. The Act outlines procedures for requesting assistance in the real-time collection of both traffic and content data from communications within Kenya. The requesting state must provide detailed information about the offense, the data sought, the purpose, and the necessity for real-time collection, along with measures to protect privacy. Kenya will seek appropriate authorization, such as warrants, to execute the request if it is granted. Designated point of contact. The Act mandates that a dedicated point of contact be available 24/7 to provide immediate assistance to other countries in cybercrime investigations. This includes offering technical advice, coordinating data preservation efforts, collecting evidence, sharing legal information, and helping locate suspects. This provision highlights the importance of rapid and efficient communication in cross-border cybercrime cases. Territorial jurisdiction. The Act clarifies that Kenyan courts have jurisdiction to try cybercrime offenses if the offense was committed in Kenya. It further establishes jurisdiction when an offense is committed outside Kenya by Kenyan citizens, individuals ordinarily residing in Kenya. The Act considers offenses committed outside Kenya to have been committed within Kenya if they are committed against a Kenyan citizen. Against Kenyan government property outside Kenya. To coerce the Kenyan government into action or inaction. Kenyan courts also have jurisdiction if the offender is present in Kenya after committing the offense outside the country. Forfeiture. The Act allows courts to order the forfeiture of devices or equipment used in committing cybercrimes to the Communications Authority of Kenya. Prevailing clause. In cases of conflict between the Act and other Kenyan laws related to cybercrime, the provisions of the Computer Misuse and Cybercrimes Act take precedence. Part 5 of the Act is crucial for enabling Kenya to participate effectively in the global fight against cybercrime. It provides a legal framework for collaboration with other countries, allowing Kenya to both seek and provide assistance in investigating and prosecuting cybercrime offenses that cross national borders. This is a summary of Part 6 of the Computer Misuse and Cybercrimes Act of Kenya. Part 6 of the Computer Misuse and Cybercrimes Act focuses on general provisions that clarify the Act's application and address procedural aspects. Here's a breakdown. Territorial jurisdiction, Section 66. This section clarifies which courts in Kenya hold jurisdiction over offenses under the Act. Offenses committed in Kenya. Kenyan courts have jurisdiction over offenses where the act or omission occurred within Kenya's borders. Offenses committed outside Kenya. Jurisdiction extends to offenses committed outside Kenya if the offender is a Kenyan citizen or ordinarily resides in Kenya. The offense targets a Kenyan citizen, Kenyan government property outside Kenya, or aims to coerce the Kenyan government. The offender is present in Kenya after committing the offense outside the country. Forfeiture, Section 67. This section grants courts the power to order the forfeiture of any apparatus, device, or item used in committing an offense under this Act. Forfeited items go to the Communications Authority of Kenya. Prevailing clause, Section 68. This section establishes that in cases of conflict between this Act and any other Kenyan law concerning cybercrimes, the provisions of the Computer Misuse and Cybercrimes Act take precedence. Consequential amendments, Section 69. This section details specific amendments to existing Kenyan laws to align them with the provisions of this Act. These amendments, listed in the schedule, include repealing outdated sections of the Kenya Information and Communication Act, 1998. Replacing and inserting new sections related to child pornography and sexual communication with a child in the Sexual Offences Act, 2011. Regulations, Section 70. This section empowers the Cabinet Secretary to create regulations that facilitate the effective implementation of the Act's provisions. These regulations may address designating critical information infrastructure, protecting, preserving, and managing critical information infrastructure, rules for data access, transfer, and control within critical information infrastructure, critical data storage and archiving requirements, audit and inspection procedures for national critical information infrastructure, disaster recovery plans for critical information infrastructure, standardized procedures for conducting searches and seizures and collecting electronic evidence, processes related to mutual legal assistance in cybercrime cases. This section also outlines the purpose and limits of the Cabinet Secretary's power to create regulations, emphasizing alignment with existing Kenyan law and proper legislative process. In essence, Part 6 of the Computer Misuse and Cybercrimes Act of Kenya addresses jurisdiction, asset forfeiture, the Act's precedents over conflicting laws, amendments to existing laws, and the Cabinet Secretary's authority to issue implementing regulations. These provisions are essential for the Act's practical application and enforcement. This is a summary of Part 7 of the Computer Misuse and Cybercrimes Act of Kenya. Part 7 of the Computer Misuse and Cybercrimes Act of Kenya, titled Provisions on Delegated Powers, focuses on the authority to establish specific rules and procedures for implementing the Act. It grants the Cabinet Secretary the power to make regulations to ensure the Act's practical application. Here's a breakdown of the key aspects of Part 7. Broad Regulatory Authority, Section 70, Chapter 1. This section gives the Cabinet Secretary broad authority to make regulations for the better carrying into effect of any provisions under this Act. This means the Cabinet Secretary can establish detailed rules and procedures to address various aspects of the Act's implementation, ensuring its effectiveness. Specific areas for regulation, Section 70, Chapter 2, while Section 70, Chapter 1, provides broad regulatory power, Section 70, Chapter 2, outlines specific areas where the Cabinet Secretary can create regulations. These areas include critical information infrastructure, designating specific systems, networks, programs, then data as a national critical information infrastructure, establishing procedures for the protection, preservation, and management of this critical infrastructure, defining rules for accessing, transferring, and controlling data within critical information infrastructure, determining requirements for storing and archiving critical data and information, setting standards for auditing and inspecting national critical information infrastructure, developing recovery plans to address disasters, breaches, or loss of critical information infrastructure, electronic evidence, establishing standardized operating procedures for law enforcement agencies to conduct searches and seizures, and to collect electronic evidence in a manner that is admissible in court. International cooperation. Developing procedures and mechanisms for providing and receiving mutual legal assistance in cybercrime cases, as outlined in Part 5 of the Act. Constitutional alignment, Section 70, Chapter 3. This section is crucial as it ensures that the Cabinet Secretary's regulatory powers are exercised within the bounds of the Kenyan Constitution. It highlights purpose and objective of delegation. The primary purpose of delegating regulatory power to the Cabinet Secretary is to enable the creation of specific rules and procedures that make the Act workable and allow the Communications Authority of Kenya to carry out its duties effectively. Limits on regulatory authority. The Cabinet Secretary's authority to make regulations is not unlimited. The regulations must directly relate to implementing the Act's provisions and must align with the specific objectives outlined in the Act. Principles and standards. The regulations created by the Cabinet Secretary must adhere to the principles and standards established in the Interpretation and General Provisions Act, Cap. 2. This Act provides general rules for interpreting Kenyan laws. The Statutory Instruments Act, 2013, Number 23 of 2013, this Act sets out the procedures for making subsidiary legislation, regulations, in Kenya, ensuring transparency and proper legislative process. Part 7 of the Computer Misuse and Cybercrimes Act is essential because it provides the flexibility to adapt to the constantly evolving nature of cybercrime. It allows the Cabinet Secretary, with input from relevant experts, to create and update specific rules and procedures for addressing new threats, technologies, and investigative techniques, ensuring the Act remains a relevant and effective tool in combating cybercrime.